there's a clarification that's coming from Abhay Sehgal. He says, I'm not an artist who can paint on black canvases. I create digital collages before I start, and I like to look at them as I paint. That's just my process. The goal is to be the best, and I will keep pushing towards my dream. So he's not apologized clearly. He's in fact justified how he paints and how he goes about creating art, for instance. What do you think has gone wrong and not worked for him?
The elements that we're looking for to show that an artwork is substantively similar are present in some of the, some of the pictures of the canvases online. And if you, I think some of the elements on the screen right now, flashing right before our eyes, a layman can look at them and say, okay, I see the original and I see this collage, whether it's on canvas or whether it's in a digital medium, I can see the original work in the new work. Now, in certain countries, for example, in the US, if this were to be done by an artist, it would be considered transformative. It may be considered an expression, a comment on the original artwork itself. And the moment it's transformative, it's a new work. But in India, we just don't have that in our copyright jurisprudence. And it would still constitute infringement. You cannot take someone else's work and adapt it to a new media and therefore claim copyright over that. And in the instant instance, it's about a digital collage being made, number one, from existing artworks, and that entire collage being painted onto canvas. So the first thing that I believe has gone wrong is that digital collage. Now, in most cases, and I'll tell you what's interesting to me, and it may not be interesting to everyone else who's not an IP lawyer, but to me, it's usually hard to prove that a person who has infringed another person's work has had access, number one, to the work,